Our next panel is, the issue is going to be defending your business against consumer protection claims. This is sponsored by Kenney Sams. First, we have Lindsay Burke, who is a partner at the firm, where she defends and asserts the rights of companies entangled in commercial disputes. Her cases often involve business-to-business contract disputes, business divorce, trade secret litigation, non-competition agreements, and questions regarding intellectual property ownership. Nate Cole is also a partner at the firm. His clients are a diverse range of individuals and businesses involved in construction, manufacturing, insurance, food services, retail, waste management and hazardous materials cleanup, commercial landscaping, maintenance, and snow removal. Alex Zawillinger is also at the firm. He is an experienced litigator who resolves disputes for companies and individuals. He handles general business litigation, representing both defendants and plaintiffs involving the real estate, technology, construction, and healthcare industries. It's all yours.
Good afternoon. So I'm Nate Cole, and I'm here with Lindsay and Alex. We're here to talk about consumer protection claims. Obviously, with District Attorney Ryan's conversation, she talked about things that we can all relate to as immediate crises. As defense lawyers, we face crises of our own, and we want to talk about how consumer protection violations can result in almost existential threats to your companies or to your clients. So it's important to understand what a consumer protection violation claim is, what it looks like, and how to both prophylactically and then reacting to the claim, how to defend against it so that you are limiting your client's exposure, you understand what the risks are, and you can advise accordingly. We're going to talk about initially an overview of the Act. Many of you are familiar in particular with Chapter 93A, the Massachusetts Consumer Protection Act. It's modeled after a federal act, but for the purposes of this discussion, it'll be helpful to talk about 93A. You see it thrown around a lot. If you're a plaintiff's lawyer, you'll throw it into many complaints to try and use as a sword. If you're on the defense side, you see a number of these complaints that include a 93A allegation. Oftentimes they appear somewhat frivolous, but when you have one that has teeth, and if you've ever faced a true 93A claim, it really can jeopardize the client significantly, and depending on the size of the client, it can wipe it right out. So we're going to look at the 93A claim, an overview to give you some familiarity with it and brush up on it if you already know a bit about 93A. We're then going to pivot, and Alex is going to talk a bit about the prophylactic measures, what you can do beforehand when you're advising a business to get the business ready so that, much like any other emergency, you've got a protocol in place that you know to follow when you catch wind of one of these 93A claims, whether it's in the form of a demand letter or whether you see it in a complaint when a complaint is brought against your client. And Lindsay will also speak to what the government is doing and how the AG's office uses Chapter 93A to prosecute claims of its own. We'll take some questions at the end, but we're mindful of the fact that we're a little bit late on time, so we'll jump right into it. The Consumer Protection Statute of Massachusetts 93A was part of a wave of FTC acts, Federal Trade Commission acts, that set the stage for acts that were enacted throughout the country. Most of the states have similar acts that deal with unfair and deceptive trade practices. And that's what the act itself is trying to outlaw. The actual language of 93A talks about unfair methods of competition and unfair or deceptive acts or practices that are conducted in the course of trade or commerce. So some of those things are really keywords that you have to be looking for when you see one of the claims. What the Act does is creates a whole new set of rights that are outside of the common law. So it's not just a matter of breach of contract or a tort. It's something that incorporates portions of those common law claims, but it gives litigants and potential plaintiffs a whole new weapon to come after businesses. Chapter 93A is the most widely used statute in Massachusetts for civil litigation, so we see it all the time. What it does is it frees plaintiffs from some of the common law requirements we'll talk about in a bit, but the remedies that you have available to you as a plaintiff bringing a 93A claim are really staggering. Right? So you can get attorney's fees, which is a major leverage point when you're suing someone. The case is just going to get more and more expensive to resolve if you're able to prevail on a 93A claim. Oftentimes you'll see attorney's fees provisions in contracts, but absent contractual language that allows for those fees, if you've got it in a 93A complaint, it gives you a lot of leverage when it comes to prosecuting the claim and when it comes to settlement. So that's a big part of it. It also results in up to triple damages. So you can have single damages, you can have multiples of that, but in a really egregious situation, a court could award triple damages. So, if you're looking at a 100,000 or 500,000 or anything in between type of claim, depending on the business, that's significant. Who can bring claims under 93A? So there's two sections that you need to be familiar with. Section 9 and Section 11 deal with the respective litigants that are able to bring claims. Section 9 is the part that deals with private consumers, so individuals that are engaged in the course of a particular transaction in trade or commerce, and that bring a claim alleging these unfair or deceptive acts. That's a Section 9 claimant, and there are specific responsibilities for a Section 9 claimant that they have to meet. We'll talk about those so that you understand in the course of defending those claims why they're so important to meet and how you can go about poking holes in Section 9 claims. Under Section 11, that's a separate section that deals with business-to-business litigation. So if you are a business and you're engaged in commerce or trade with another business and there's been this unfair or deceptive conduct, you'll be able to bring a claim under Section 11. The responsibilities and the rights are a little different. We'll talk about that. Generally, the courts are a little more lenient when it comes to at least what constitutes unfair or deceptive from the perspective of a Section 9 individual claimant. When it comes to businesses, it has to be something a little bit more than your typical run-of-the-mill bad behavior. And government entities, the Attorney General can use the act as well, as Lindsay will speak to. Under 93A, the potential defendants, folks that you may be representing that are facing one of these crises, any person or business that's engaged in trade or commerce, there's a lot of case law on what constitutes trade or commerce. And that's something you need to be looking at when evaluating one of these claims. But it's defined by the Act. The Act itself has relatively straightforward definitions where you get the meat of what constitutes the specifics of the language. It's in the case law, and there's a lot of case law for 93A. The other key part is the unfair or deceptive practices section. What constitutes unfair and deceptive practices under the Act, what you're thinking about here is it's not just a breach, all right? It's not just a violation of a common law standard of care for a tort. It's something that goes so far above and beyond that that it really tilts the balance in terms of equity and fairness and how you're negotiating in the marketplace. The idea is to tilt that balance back in favor of the consumers, whether they are individuals or whether they're businesses. But what constitutes the unfair or deceptive is evaluated according to the cases on a case-by-case basis, right? So such a lawyerly answer to the question of what constitutes it. But you have to look at the cases. And you've got to find cases that are on point to be able to evaluate whether the specific conduct that you're looking at when you are either bringing one of these claims or when you're in the position of defending against one of them, whether you can evaluate whether there's real exposure here for your client for 93A. You've got to look at the cases. The Act itself distinguishes itself from the common law claims. That's the whole design of it. They're not dependent, that is 93A claims, on whether there's been a breach of contract or a tort. And by that I mean you can have situations where there in fact may not be a breach of contract or there may not be a violation of that common law duty, and judges can nevertheless find 93A violations in the conduct itself. So it seems a little counterintuitive. And to add to that sort of counterintuitive nature, the claims for 93A nevertheless have to have some relation to what we think of as common law breaches of tort or of contract. What distinguishes a 93A claim from a typical breach of some sort has to do with this unethical, unscrupulous behavior. And there's some really colorful language in the various cases. Some of it is helpful, some of it is not, that talks about the rascality of the behavior. What does that mean? Good luck. You'll point to a case that says rascality and then try and find the comparable behavior. But what I think you want to take away from it when you're looking at these claims is just how sort of diabolical they are in shifting the balance of equity in the marketplace. That's, I think, the gist of the claims. Another thing to look at is that there are a number of statutes in place or regulations from the state that are either per se violations of 93A. So there's the Home Improvement Contractor Statute, Chapter 142A. In the statute itself, the very last line of it says that a violation of this statute is a per se violation. So you may have a claim come in that talks about someone violating a home improvement contractor statute, and you're representing a contractor, and you look to see, geez, it doesn't seem like much of a violation. It's, there may be a deficiency in the contract language that doesn't include the start time and the end time of a project that's performed under that statute, the violation of that statute can then trigger so much more substantial penalties to a particular company, right? So if you've got a 142A violation and you're able to establish this causal connection to the violation of the statute and the damages, then you're looking at a massive statutory violation of 93A, and you're looking at attorney's fees. Someone can take a $25,000 dispute, and if they go all the way, and we've seen this happen, where they litigate it throughout the course of 2 or 3 years. We've won cases over $25,000 disputes in which there's $200,000 in attorney's fees, and the courts will allow that. Query what sort of litigants want to fight for 2 or 3 years and have the resources to fight for 2 or 3 years over $25,000. But it happens, and you need to be aware of it when you see that claim come and advise your client that what could be a relatively minor claim to resolve could end up costing that client multiples of what it would take earlier in the case. Another interesting part of 93A, and sort of staggering, is the way that it changes some of the relationships that are necessary in a traditional common law sense. So privity of contract. You can sue for a 93A violation alleging a breach of a contract to which you're not even a party to. So someone is out there, the beneficiary of a warranty, they're able to bring a claim now. Previously, under traditional tort concepts, you can make the argument that there is no privity. But with 93A, you just allege the breach of contract over here. You allege that the conduct itself is in the course of trade or commerce. You're able to prove that it's this level of rascality or unscrupulous, unfair, or deceptive conduct, and you've got a 93A violation. Similarly, what constitutes an injury, in particular when you're dealing with Section 9 consumers, essentially individual litigants, is a lot different in terms of it has to be any sort of injury. It can be economic, it can be non-economic, it can be what we traditionally think of as injury, but it can include things like racial harassment. The cases are very clear on that. Slander, defamation, these sort of tort concepts that if there's a violation, again, triggering pretty massive consequences. On the flip side, illegality is not necessary. There can be conduct that is in fact authorized by statute that nevertheless can result in a 93A violation. So for example, under the statute, if you're allowed to bring a lawsuit and collect a debt, it's not illegal. If you use that sword of collecting a debt and bring it against an individual in 7 different venues and jurisdictions throughout the Commonwealth, and you're doing it for the purpose of gaining this strategic advantage by essentially trying to bleed someone out, and they're forced to defend as an individual or as a business in multiple venues, that in of itself can create a 93A violation, even though the underlying litigation is authorized by statute. Similarly, and we see this a lot, is sort of groundless litigation, that can be a 93A violation. Similarly, meritless defenses can be a 93A violation, but where you see it quite a bit is where there's an undisputed amount of money that is owed, and people are taking an opportunity to fight over that undisputed debt that they owe to try and leverage themselves into a better position. If you've got a breach of contract and you owe some amount of money, and you try and say to the other side, I'll pay it, but you're going to reduce the price over here, that can result in a 93A violation. So you have to be very mindful that if there's not a contractual provision in your respective client's contracts with another party that allows them to use on one contract dispute to offset another dispute, and instead you're simply trying to use one to offset the other, be aware that that can cause a 93A violation. So if you're sitting down with a client and saying, hey, you don't have any defenses here, that's okay. I want you to hold off on that money and paying what I owe until they give me a better deal on this other deal or this other part of a project or another contract. That's a 93A violation. Ironically, not all illegal acts violate 93A. So you could look to a statute, and there are cases in which there are violations of civil statutes, in which the behavior, although it violates this statute, does not necessarily rise to this level of egregious wrongdoing. Again, case-by-case basis, but what you're trying to do is look to see whether the underlying conduct rises up above typical breach of contract. Good faith disputes are not 93A claims. You'll see it thrown around a lot, but push back when someone makes that allegation. It's not. If it's just a straightforward dispute, you've got good faith reasons to be arguing, don't take the bait on 93A. Negligence enough, similarly, is not enough. It's when you see this deceitful, dishonest type of conduct that involves a level of knowing. The cases take a closer look at exactly what did the individual that's alleged of the violation, what were they aware of in terms of their behavior and in terms of the leverage they were trying to improperly use in the course of trade or commerce. I'm going to move through the AG regs quickly. Lindsay's going to talk about those in more detail. But there are various CMRs that the AG and that individual litigants can use as a basis of establishing a 93A violation. Those statutes that deal with the health, safety, and welfare of the public, building codes, for example, 142A, the Home Improvement Contractor Statute is another. When you're violating those, you're now wading into the waters of potentially triggering a claim under the Consumer Protection Statute. We touched on this a little bit, but the difference between Section 11 and Section 9. So Section 9, again, being individual consumers, private litigants, and businesses. The courts do hold the level of behavior between businesses to a higher standard. And by that I mean, not that they're expecting better of them, in fact, they're expecting worse. If you're in business in Massachusetts, it's the rough and tumble world, and so the courts are a little bit more lenient when it comes to what constitutes 93A conduct from business to business transactions, much less so when you're dealing with individual consumers. And I think from the perspective of a trial lawyer, and you're evaluating these cases as a story of human drama that you'll be telling to a fact finder, whether it's a jury, whether it's an arbitrator, or whether it's a judge, you've got to think of it in terms of how bad does this look to someone? It's a much different scenario, I'd submit, if you're talking about a little old lady that's being taken advantage of by a big bad company in a 93A context than two massive corporations that are informed, that are represented, that are going at it one another. It's not to say that you can't have it with the two big businesses going at it, but the cases certainly are a little bit more sympathetic towards the individuals. It's the extortionate quality of conduct that rises to the level of the rascality or the egregious behavior in the context of business to business, where you'll find the court saying, even with a business, that's over the line in Massachusetts, we're not going to allow it. And also the good faith and fair dealing. So typical breach of contract usually doesn't rise to the level of 93A, but when you're alleging good faith and fair dealing, right, this sort of the implied covenant that businesses and individuals and consumers are going to negotiate fairly and not be misleading and not be tricking and not be withholding information, if you start to go in that direction and you're seeing factors that would establish a breach of the covenant of good faith and fair dealing, again, intent is up. You can bring these cases in Superior Court, and Superior Court has monetary, equitable, injunctive, declaratory relief. You can get those claims heard in Superior Court. Housing Court, 93A claims with regard to specific issues of housing. The Housing Court does have jurisdiction and can find 93A violations. They can hear those. District Court, I expect we'll see a lot more 93A claims brought in District Court as the jurisdictional amount in January raises from $25,000 to $50,000. You know, they're pushing us into the court. District Court's a whole different beast. You've got 6-person juries, and Superior Court Rule 9A doesn't apply. They have their own set of rules. It's a little bit of the Wild West for those of us that are accustomed to practicing in Superior Court or federal court. But we expect to see more cases shift into District Court where there are those violations of $25,000 or $30,000 of alleged violation that they can then tack on a massive amount of attorney's fees or multiple damages. And in federal court can evaluate the 93A claims depending on whether the case is properly there on the basis of diversity or federal question. So 93A is everywhere, and you'll see it in all the courts. We talked about the difference earlier of a Section 9 litigant versus a Section 11 litigant. Section 9 litigants must, the individual consumers that are bringing a claim against a business must send a demand letter that has very technical and specific requirements that have to be met. So if you are in receipt on behalf of a customer or your business, if you're in-house, of a Section 9 letter or demand letter of any type that alleges 93A, now it's a crisis, right? Now you have to look at this and take this very seriously. And the first thing you want to be doing is evaluating whether or not the letter that you're getting from a Section 9 litigant meets the statutory requirements, because if not, you've got some strong defenses that you're going to have to figure out, as we'll talk about in a bit, how you utilize those defenses, whether it's in the course of responding to the 93A letter, which you've got to do under Section 9, whether it's in the course of how you strategize your response to a complaint, whether it's in the form of a motion to dismiss or other tactics that you may take. The cases are very firm, even with individual litigants under Section 9, about these requirements, right? So you have to allege a 93A violation. That has to be implicit, but I would argue if it's implicit and it's not clear, push back on whether that letter satisfies the requirements of 93A. The actual unfair or deceptive acts similarly have to be pretty clearly defined. The injury has to be reasonably defined. The letter itself has to go to the individual defendant. So there's case law that suggests that if, as a lawyer, you're in receipt of a 93A demand letter on behalf of your client, that probably is enough that it would be able to pass muster with the courts. But I think you could push back and argue that if my client didn't get it, you don't satisfy the statutory requirements, you may be blowing it. If it goes to an insurance company, and if any of you are in-house representing carriers, or you're in-house representing a business and you don't get, or your client doesn't get that letter, and it just goes to the insurer, remember that, because that's going to be a very strong defense to push back on the allegation of 93A and that they satisfied the requirements. The other part that I think is critical is if you get a counterclaim of 93A, even when it's from a Section 9 litigant, the demand letter in that situation is not necessary. Oftentimes, we'll advise clients to send one anyway. And we'll do that in the context of Section 11 litigants. We like to start the process out with a really comprehensive demand letter if we're sending one out. And if you're getting one in, take it as an opportunity to look at this seriously and immediately start the processes that we'll discuss in a bit to how to properly respond. Responses to the demand. I want to go over it generally, but Alex will jump into it in a bit more detail in terms of tactics of how to do it. But you want to get this thing in, and don't let a day go by before you reach out to your client and sit down and advise them. You've got a 93A letter that's been served on you. If you get it from a client and they wait 10 days to get it to you, you need to impress upon them how quick it needs to be turned around, right? So it's all hands on deck at that point. I think you can reach out to opposing counsel and request a brief extension if that's appropriate, depending on the relationship, depending on how you want to proceed. You may not want to do that, but be very, very mindful of the 30-day clock that's ticking. You need to get the response out. The next part of it is the investigation. So this is going to tie in to the reasonableness of the response, but implicit, and I think inherent in a reasonable response to a 93A demand letter is going to be the reasonableness of the investigation itself. I don't think the best approach is to suddenly scramble and figure out how to investigate one of these things, but oftentimes that's just the position we're in. We like to advise clients to have a protocol in place so that they know exactly what to do the moment that they see the words 93A. But oftentimes you're just getting this letter and it's mailed to you and a client doesn't appreciate the import of what's going on. The letter, in terms of the response to the 93A demand and the 93A demand itself, are likely going to be exhibits at the trial of the 93A allegations, whether it's before a judge or another fact finder that's evaluating this. So think about that. What you're drafting, someone's going to look at and going to be looking at it line by line to determine whether you've complied with your statutory requirements and whether you've effectively responded and pointed out the deficiencies in the incoming demand letter. We cite the specific cases. So if you've got a pushback on why something is not unfair or deceptive conduct, if you've got case law that supports your position that the entities are not engaged in trade or commerce, but are rather in a private exchange, two private individuals selling real estate back and forth with one another, that's not necessarily trade or commerce. They're in a private exchange with one another. But you want to take the opportunity to really push back with comprehensive case law that supports your position. That is going to ultimately be evaluated by someone down the line when they're looking at whether it was a proper response. A good response to a 93A demand is going to do a few things. One, it's going to limit the damages right there in terms of attorney's fees that are incurred going forward. So that's a huge part of it. It's going to limit the potential for multiple damages going forward. Even where your client has done something willful or deceitful, if you make a good faith, reasonable settlement offer as part of the 30-day period where you're responding to a 93A letter. That's going to eliminate a lot of the damages. So you've got to convey to your client that they may be in that mindset of, I've done nothing wrong and I've got nothing to worry about and we want to fight and I'm not going to pay a penny. Your job is to explain to them that if you're wrong, and our investigation is showing that there's some exposure here, if things unfold and they get worse, or we're not seeing things right now because you haven't given us all the information, even despite the fact that we've conducted a thorough investigation, the failure to make that reasonable offer is going to be very expensive down the road. That's not to say that you just make an offer in any single case. So we will evaluate cases. If we think that the claim is frivolous or we think we have strong defenses, we will oftentimes recommend a zero offer. We also will hedge a bit by suggesting mediation. That's a reasonable approach, even where you've got a litany of strong defenses, where you've got the case law on your side. I think a judge later on looking at that can say, at this moment in time, early in the case, they took it seriously. They attempted to resolve the dispute. I think stepping back, one of the biggest reasons why the legislature and legislatures throughout the country have put forth these Consumer Protection Acts is to encourage settlement discussions. They don't want everyone rushing to court over these actions, and they've taken it as an opportunity to say, sit down, especially where someone has allegedly done something bad, and see if you can resolve it so the person doesn't have to chase after you. But if you make them chase, and if you make them incur these expenses, you're going to get whacked, and it's going to be painful. And there's a punitive nature to that, certainly, in the attorney's fees and in the multiple damages. That is the point. Verdict research. It's another thing, if you find favorable verdict research, to strengthen your offer and to support the reasonableness of it. Conversely, if you're looking at verdict research that's showing that the value of this claim based on the liability and the claims that are being made is a problem, then your offer has to reflect that verdict research, or you're going to expose your client to further damages. Don't bury your head in the sand, and I think lawyers aren't going to do that. Clients do, and they just underestimate the import of these. So part of what we'll talk about too is if you take nothing away from this, go to your clients and explain, when you get a 93A, please be aware of what it is, what it means, what it can do in terms of damage. You have to get that to us same day or within a matter of days. We've all had those situations where clients push things along. Hey, I wanted you to take a look at this letter I got. It says something about 93A. I didn't do anything wrong. Suddenly you're 14 days in and you don't have time to conduct a comprehensive, reasonable investigation, and you're in some trouble. Claims under Section 11, a little different. So these are business-to-business claims. Oftentimes, attorneys for business litigants, plaintiffs, do in fact send out a demand letter. It's an opportunity to lay your case out and put some fear into them based on the allegations and the facts that are in support, verdict research that they've got exposure here under 93A. So if you do get one of those letters, we will respond to them and we'll conduct the investigation and follow the same protocol that we set forth under Section 9. But there is no requirement under Section 11 that business litigants send a demand letter. So sometimes the first time you'll hear of a 93A alleged violation will be in the form of a count and a complaint when your client's getting sued. Nevertheless, like Section 9, you can limit those damages by making a good faith offer. So you should do the same things, whether it's 9 or 11, whether you're representing a business getting sued by the individual or another business. Conduct the investigation, evaluate it thoroughly, tell your client about the risk, and think about how you eliminate that exposure by making the good faith offer. If you get one of these claims under Section 11 and you can make the argument that the conduct alleged did not substantially occur in Massachusetts, even if there were two Massachusetts companies and they were negotiating the contract itself, if the allegedly violative conduct is outside of Massachusetts substantially, that's a strong defense. Okay, so you've got the complaint now, whether it's Section 9 or whether it's Section 11. You've got some options to think about, and you've got to advise your client accordingly. Do you move to dismiss? If you're moving to dismiss, you've got 20 days within receipt of the complaint, but you don't always want to move to dismiss a 93A claim. It's going to be expensive for the client, and most likely the court's just going to punt on this thing and tell you to conduct discovery and come back when it's motion for summary judgment time. So you want to think about whether that is the appropriate approach to a complaint alleging 93A. If there's a 12B6 motion and that's there, whether you look at this complaint, you look at the allegations, you look at the demand letter and the response, and you can make an argument that as a matter of law, there's a private transaction that's taken place here, and it's not within the course of trade or commerce. You can certainly consider a motion to dismiss there, whether it's an internal employment dispute, or these transactions that are taking place principally outside of Massachusetts. Those are really strong arguments that I would consider a motion to dismiss at that stage. Alternatively, if you're going to answer the complaint and you're going to instead say we'll take some concise discovery, we'll push back and we'll establish that there's no 93A violation as a matter of law, and we'll save this for motion for summary judgment, then you've also got to think about the affirmative defenses. And you've got to specifically allege those. You really should in detail push back on exactly why the specific 93A claims, line by line, are not 93A, and they don't reach that level of rascality. But those are things you need to think about as you get it in. But any of the failure to send the demand letter, if they didn't send it to the right person, if there's an unreasonable acceptance of a settlement offer, so someone is making a claim and you're looking at it and they've got X dollars of a finite amount of damages and you make an offer and they don't accept it, then I think they've lost the right to proceed with a 93A claim, and as a matter of law, you may want to think about moving to dismiss that claim or quickly moving for partial summary judgment, if nothing else, and pushing back. You also want to look and keep an eye on the statute of limitations, 4 years. That's another strong argument to be able to push back in the form of a motion to dismiss or summary judgment. Some additional considerations that you want to be mindful of. Whether it's a claim under 93A that you want a jury to take a look at. So plaintiffs have the right to ask for a jury trial or bench. You have the right as a defendant to push back on that and ask as well. It's not dispositive. The judge is ultimately going to decide whether to refer it to a jury and have a jury take a look at the claim. But you want to think about the nature of the claim and, based on your investigation, how strong or how weak of an alleged 93A claim you're looking at. If it's a highly technical claim, certain construction disputes that deal with things that a jury's going to get lost on, if it is particularly nasty looking in terms of the deceptive quality of the conduct, if it is a claim that's being brought against your client and your client's involved in professions that are not exactly held in high regard by the public, those are claims that I think are best heard by a judge on 93A. Alternatively, if you think you can tell a good, compelling story in which this is an overreach on the part of the plaintiff or the plaintiff's lawyer, and they're just throwing this claim in there, you may want to think about whether you'd like to tell that story to a jury. That's a consideration that you definitely want to have, though, with the client, especially if the plaintiff has not requested the jury and you think it's a matter that should be in front of a jury and you request that the judge put there. Arbitration provisions and 93A when it comes to arbitration. Courts, when it comes to business contractual arbitration provisions, much more likely to allow it to go forward in arbitration, stay the case, or even have an arbitrator provide an opinion that they can then bring to Superior Court or the respective court on the 93A claim. Less so forcing private litigants, if it's a purchaser of goods of some sort and there's an arbitration provision in the fine print, courts have allowed the 93A claim to go forward irrespective of what's going on with the arbitration. So keep an eye on who the litigant is and whether you've got arbitration provisions and how you want to push back. Think about that at the outset of the case and when you see the letter come in. And then I'm going to turn this over to Alex to talk about further strategies when it comes to 93A. Thank you.
So claims under 93A at first might seem very different than active shooter sort of crises, or if you represent Boeing and you're dealing with 737s that are falling out of the sky, or you represent BP and there's oil spilling into the Gulf. Those are a certain type of crisis. But if you represent or you are a small business, a claim in which the damages could be doubled or tripled, or where the claim might be small, but you might end up having to pay not just your legal fees, but your opponent's legal fees, can be a real crisis. It could be the kind of thing that can change the projection for your company, the livelihood of your company. So it's very important to take that seriously, and it's very important to plan strategies for dealing with really the sharpest teeth of 93A, which is multiple damages or attorney's fees. Something that I'm not sure, I know Nate mentioned attorney's fees. Something that's most important about attorney's fees is that unlike multiple damages, where it's only in the most extreme cases where a court's gonna grant those. Attorney's fees are automatic. If you prevail under 93A, your fees are going to shift, which is going to be a big part of your negotiations early in the case, but then also in any sort of like award after trial. So some strategies for dealing with those two issues of multiple damages, but then also fees, sort of fall into two categories with subcategories. So the first would be proactive steps you could take to try to mitigate those risks before you even have a problem. One of the first ones you can do, and we'll go through these in more detail, would be to contract to address those risks, to deal with them in advance and limit them. You can plan, which is something that I know I heard throughout the panels and the speakers today, which is that you should always have a plan for dealing with these crises in advance, because the worst thing you could possibly do is fail to plan and then deal with, be faced with a crisis and not have measures already in place, or the people that need to address these crises aware of the best next steps, who they need to talk to. So we'll go over those. In addition to that, 93A has these very potentially punitive measures of multiple damages or shifting fees, but you could do something once somebody brings one of these claims to cut those off, and then we'll talk about how to investigate and then how to respond. So one of the first things you can do well in advance is to contract prophylactically with your contracting party, the counterparty. You can limit the possibility of multiple damages or the potential exposure under 93A in advance. Importantly, however, this is only going to apply to Section 11 claims for commercial contracts among businesses that are engaged in commerce. You're much more likely to withstand the sort of scrutiny that a court's going to apply to this kind of waiver if you can show that these were sophisticated parties dealing at arm's length, you have counsel present, but you're not going to have that same sort of option if you're dealing with consumers. So one of the important things to do when you're planning and contracting for potential 93A claims is to consider who it is that might be making these claims against you. A consumer is likely not even going to know that 93A exists until they've been wrong. They probably aren't discussing with counsel their potential claims or potential risks that they're encountering when they're dealing with you as a business. And when we were talking about this, you might want to even consider whether you run a risk of creating a 93A claim by trying to contract out in advance with a consumer, somebody that doesn't really know these things. So importantly, not just including in your contracts with businesses to limit these sorts of multiple damages or attorney's fees risks under 93A, think about how you can distinguish between contracts that are using in business-to-business relationships as compared to with consumers. Also important is to note that this isn't going to solve all of your problems. The courts that have looked at waivers, prospective waivers in contracts, have taken pretty limited approaches to how they apply. It's not going to apply to torts that aren't related to the contract. It's not going to apply to claims that result or arise from conduct besides in the contract. And from the cases I've read, it seems like even where the contract is at issue or the claim could somehow tie back to the issues in the contract, courts are not keen on enforcing these sorts of waivers. But it is something that you can build in advance. Something also to think about is whether you want to, if you're going to contract in advance to waive potential 93 claims against you, likely you're going to have to waive them for yourself, and it's likely to be a mutual waiver. Think about who amongst the parties to your contract are in the position most likely to be wronged in this sort of extra rascality sort of way. Think about also arbitration provisions. So these claims come up not just in the context of the district and superior or housing courts, but also in arbitration. And just like any arbitration where you're defining the scope and the powers of your arbitrator, the rules are going to apply. You can contract out of these sorts of for arbitration. It's something to consider adding to your arbitration provision. If you are or you represent a business, you probably have that in there. It's probably something that you've identified as in your interest. It may also be in your interest to be able to limit the potential for these growing damages or fee shifts. The other thing, and again, this is something that came up throughout the day, is plan in advance. That's the most important thing to deal with any sort of crisis, and those sorts of crisis management strategies and suggestions that we heard throughout the day dealing with these, real, I don't want to say that 93 is not a real crisis, but, if you're Boeing, you should be planning on plane crashes. If you're a business, you should be planning on business crises. You should think in advance, ask yourself, who in your company might violate 93A? Who deals with the consumers directly? Who deals with the other businesses that you're engaged in trade or commerce that may create the sorts of liability you might experience under 93A? Do these people understand when they're dealing with consumers or with other businesses that they might create this sort of liability for you? And a story that Nate told me a couple times, so I feel comfortable saying this. It was I'll say it was Nate. I was debating whether I was gonna divulge that it was Nate. Was dealing with Eversource, who cut the power to his house. He had, and I think also there was a dangerous condition in the way they were running the service to the house. He had to hire an electrician, and he incurred out-of-pocket expenses, and went to Eversource and say, "Pay me these out-of-pocket expenses now." I mean, these are the sorts of issues that, as a consumer, the businesses should be prepared to handle.
Well, and just to jump in, there were a number of violations there. So there was my daughter at the time was 3 months old. There was another baby in the house. There was a problem with the power coming to the house in the middle of February. It was freezing temperatures. So I got this call that power's out in half the house. I call Eversource and I go home and I meet up with an electrician. And the Eversource crew came and took a look and tried to figure it out, and they couldn't. So they packed up and left. It was 5 o'clock. The electrician says, you own, as a homeowner, from the meter into your panel inside the house. And I'm testing it, and I'm telling you right now, it's working. Both the lines for the 220, 110 on each, are functioning properly. It has to be them. You got to call back. So I called back Eversource, and I spoke to someone on the line. I said, you need to get someone out here immediately. It's 16 degrees. And if you don't fix this, you're going to be looking at property damage in the form of frozen pipes. It was now down to about 52 degrees inside the house. And I have a 3-month-old baby in the house. It's a violation of a number of statutes and regs. The person on the phone was not prepared to answer my questions and be able to point me in the right direction. I made sure that they were creating a paper trail, and I repeatedly said, you can put my name down, and I'm asking for these things, please record this. Eventually, they came and fixed it, and they dug the street up in the middle of the night, and they admitted it was them. And when I reached out to the same consumer protection line and hotline and asked for them to simply reimburse me for the electrician expenses that I'd incurred, they blew it off. And I sent a letter, and I alleged 93A violations and a litany of the specific regs that they had violated by shutting the power off. They blew it off. When it finally got to the desk of a lawyer, someone that I'd practiced with and come across in the course of practicing as an attorney, I got the phone call of, what do you want? I said, I want multiple damages and my fees along with the landscaping fees now that I've incurred for the repairs to damaging my property. I want the fees for the electrician. What was a $1,500 problem that they could have solved by having people that were trained to know to respond seriously to these questions and allegations resulted in a pretty significant settlement that I was able to extract on the basis that I had them dead to rights for violating 93A. And I'd given them every opportunity, and looking back and sort of, as we reverse engineer this for our own clients, and as we share this story, the point of it is they didn't have people trained for taking the phone calls from consumers to identify that this is a serious violation, and no, you're not gonna tell the consumer on the other end, well, let us know what happens and we'll take a look at your bill after you paid it. I said, I'm not paying this, you are. Long and the short of it is I got a settlement with multiples of the amount that they could have got rid of it for and got rid of me for. And I knew what I was doing. And one of the arguments I made to them was, what if I was the woman that lives next door who's by herself and is 84 years old and doesn't know the rights that she has? I knew them, and they still wouldn't pay attention to me until they got a complaint that I filed in district court. And then they answered the complaint, and then they called up and they paid me a good chunk of money. I mean, relatively speaking, but for what they could have got rid of it for. So part of it, what we take from this is train yourselves, your clients, to understand how these little moments can become much bigger for a company, let alone if it's an actual dispute over tens of thousands of dollars. But I paid my bill. Alex forgets that part of it. That's not why they shut it off.
But the point again is that if you train your employees in advance, you can avoid these problems becoming bigger. And 93A has this multiplying effect of what could be a small problem that turns it into a bigger problem. The same sorts of, as I said earlier, the general crisis management, risk management strategies that you're employing throughout your business can apply also for claims under 93A. Once you get a 93A demand letter or you are sued under Section 11, the first thing you should do is investigate. That's it was also something that came up earlier, but here in particular, it's important because you are probably being brought in after the fact. It may be days after the demand letter is delivered. It may be days after the complaint is filed, and you have a relatively short amount of time to do an investigation that is thorough. But it has to be thorough and something that you can then defend in court as objectively reasonable attempt to understand and evaluate the claim. That's really what you need to do. You need to send out a litigation hold, gather documents, talk to witnesses, understand the claim, and devise, as best you can, a strategy for responding based on the facts, based on the law, and based on your analysis of the potential exposure. That may include going to the other side and asking for more information. It may go hand in hand with a request for an extension, but the other side, the claimant, has a duty to give you that information. If they're going to take advantage of this statute, it's incumbent on them to provide you with the information that you need to properly evaluate the claim. When you're doing the investigation, think about how to maintain the attorney-client privilege. That's something that can be the subject of an entire conference in and of itself, but internal investigations of any sort, you need to make sure that you're doing it in a way that's going to protect your interests throughout, not just in terms of responding to the 93A claim, but then also maintaining the attorney-client privilege. Now, the real counterbalance to the multiple damages and fees is that if you respond to a 93A Section 9 demand letter or a Section 11 complaint claim, or if it comes in the form of a letter, by tendering a reasonable offer, an objectively reasonable offer in relation to the actual damages suffered, you can limit the damages that the claimant can potentially recover. They won't be able to get the multiple damages, and you would limit it also to the extent of your offer. This applies also to fees, which means that after you send this reasonable offer of settlement, if it's rejected, any fees that the claimant incurs from that point forward would not shift to you. It basically takes the teeth out of a 93A claim. So it's incredibly important that when you formulate your response, you take advantage of this opportunity to make a reasonable offer, if that is the best option strategically. Your response should be thorough. Being mindful of the time, move ahead a little bit. You should make sure that you respond to each of the factual allegations, come up with your best legal defenses, or affirmative defenses, and also consider whether or not it makes sense at this point to bring counterclaims, whether you have a 93A counterclaim that can counterbalance and sort of take the wind out of the sails of the other side. Ultimately, what you need to do is prepare a reasonable response that is objectively reasonable to a court later on, because if you make an offer and it's rejected, you can include that as a defense, or you can submit that to the court as basically a total defense to the 93A claim. It's determined at the time of the letter. It doesn't have to be after the full benefit of discovery, but it does need to be objectively reasonable after a reasonable investigation. And the burden is going to be on you to make sure that that is shown to be reasonable. If you're going to make an offer, you should do it strategically. And something to consider is most cases do not go to trial. Most cases settle. So you want to make an offer that I would suggest maybe would be like the first or second offer you would make in a mediation, something that is reasonable, that you can defend, that if a court is looking at and scrutinizing, they would say, yes, this is a reasonable offer. But you want to make sure, so you want it to be high enough to sort of pass that reasonableness test, but also you don't want it to be so high that you can't later go back. You want to basically put your first settlement offer out there early. Also very importantly is you don't want to blow it off. failing to respond when there is a claim, and you know that, can itself become an actionable issue under 93A. Like I said, consider whether you can go back on offense, because the plaintiff or the claimant is talking to their lawyer, thinking, this is great, we're going to be making a 93A claim, we're going to get our fees, we're going to get multiple damages, and the other side knows it, and that's going to be our leverage. If you can come up with a similar sort of claim, you might be able to take the wind out of your sails, out of their sails. Section 11 doesn't require a demand letter, so you're not necessarily going to get the benefit of the 30-day notice, but you will have the opportunity to respond with a tender offer of settlement as a defense, or after you get the claim. So government enforcement, I'm going to hand it over to Lindsay.
Thanks, Alex. So I realize that I might be the last person between you and a Thursday afternoon happy hour, so I'm going to be really brief because I never want to be that person. But I want to talk briefly about the government's authority to enforce Chapter 93A. What we've been talking about so far today has been the civil lawsuits between private litigants. It's just really important to keep in mind that the government, through the Attorney General's office, also has authority to enforce the statute, and indeed is tasked by statute with protecting the consumers of the Commonwealth and bringing these actions to protect their interests. Typically, you'll see an Attorney General action in a case where it's really egregious behavior or affects a huge number of people. The kind of, and I'll go over some of the cases that we've seen this happen in, but it's not going to be your typical one person's been harmed or one business has been harmed. Usually this is kind of impact litigation that's meant to benefit a large number of people. The other, just kind of one nuance of this that I want to point out, various administrative agencies within the Commonwealth, especially professional licensing type agencies, also have independent authority. So if someone is practicing in a profession without being properly licensed, those different agencies often have their own independent enforcement capabilities of this law, separate from the Attorney General. So the Attorney General has broad investigatory powers. Her authority has expanded over time. I won't, here's a little timeline of some of the ways that the Attorney General's authority on this has just grown and grown and grown, and more has been brought within her authority. And I will tell you that the trend that we expect is that that is going to continue. People really like the fact that there is this kind of watchdog out there that's looking out for consumers in the Commonwealth. And there's certainly not been any kind of effort that I am aware of to try to cabin that kind of authority or to restrict that in any way. So we should expect this to continue. It's a really powerful tool that their office uses. The way that you will likely see this happen is a civil investigative demand, a CID. That's how these things start. It's basically a subpoena. You'll get something, or your client will get something from the Attorney General's office saying, we're doing an investigation, here's generally what it's about, and we want these documents. And we want them probably in some very short time frame. You have 21 days to object to this in court, or less if they give you less time to respond. So if it's a 10-day turnaround on that CID, you have 10 days to get into court. You should, if you are concerned that your client is going to be in a lot of trouble if they give over these documents, moving for a protective order or some way to limit the scope of the CID or to buy yourself some more time is a good idea. I will tell you, though, that the courts are extraordinarily deferential to the Attorney General on these. Generally, what the Attorney General wants, the Attorney General gets in these investigations. They don't need to show probable cause. They need to show that they have a reasonable suspicion that something happened. And really, the best you can sort of hope to do is to try to cabin the investigation in some way. If the investigation is going to, if the CID is going to turn into a full-blown investigation, you will get 5 days notice of that unless the Attorney General is seeking a temporary restraining order, and she often does. And again, in a temporary restraining order or injunctive relief situation, her standard is different than you would typically see in these cases. Usually to get injunctive relief, you need to show that you'll otherwise suffer irreparable harm. The Attorney General only needs to show that it's in the public interest that she get a restraining order. So again, the scales are tilted in her favor in order to get these when she wants them.
Can I ask a quick question on that?
Yeah, sure.
Does the Attorney General have to seek prior prior approval of the court if they're going to be conducting some kind of warrant, or do they have to seek a warrant, I guess, to do a CID? Say they call up my client, or they present my client with some documents, a CID, and they say, we want to come in and look at all your business records for the last 10 years. Do they need some kind of prior approval?
They do not. So there's a chain of approval that needs to happen within the Attorney General's office. And I say that because often the practicing attorney's response is to call this, AAG and say, I want to talk to your boss. And that person says, my boss authorized this, and so did her boss, and his boss, and their boss. But they do not need court approval. And so,
As counsel representing a company like that, you have to go to court and try to get it
right, that's why
assist order?
I try to get a protective order right away, or some sort of modification order saying 10 years is unreasonable, we'll give you 3, or something like that. But it's on you to go into court and get that protection. And again, the court is likely to side with the Attorney General unless you do a really good job explaining why. And the burden, it basically has to be that you're about to put this company out of business if they have to comply with this. It's not just that it's too much, it's too soon, you have to show that you will be, the burden of doing this search will put you out of business. The other thing to keep in mind if you're responding to a CID, sometimes 93A conduct overlaps with criminal conduct. You may want to get a criminal defense attorney involved, and quickly, because there is an immunity in this section in terms of the things that you produce to the Attorney General are not to be used in a criminal case against you for identical conduct. But identical conduct, that's pretty narrow, and also if there are additional documents, apart from what you turn over voluntarily in response to the CID, those could be used against you in future criminal action. And so if you're being accused of some kind of fraud, that fraud could have criminal implications as well as civil implications. So before you start turning over your files to the Attorney General's office, getting a criminal defense attorney involved is a potentially good idea. That immunity in the statute does limit your ability to claim a Fifth Amendment protection and plead the Fifth, essentially, and say, I'm not going to incriminate myself. So you have to be a little bit careful with that. It's just something that I'm trying to flag for you, that there are constitutional issues, involved with turning this stuff over as well. So again, here's a 21-day window. It's really tight. That's really tight. And if the CID has a shorter time frame, the shorter time frame is what applies. Sometimes you don't get this from your client until that date is close or past. I've had some where the clients are giving it to me when it's long gone, or they've even already started to produce documents. They're trying to be helpful. So it's just a really tight time frame to keep in mind. The Attorney General does not need to show who is the target of the investigation. Often it's the person receiving the CID, but not always. Sometimes they're looking for information to help support their investigation into someone else. And you don't necessarily know if you're the target, or if maybe they think you're going to be a target eventually, depending on what they see in these documents. And they don't have to tell you that. They do need to explain what the investigation is about, but that's really all they have to tell you. There is some confidentiality protection. They're not supposed to use these documents for anything except for a court case. But if it does proceed to some sort of a trial or some sort of a filing, they will be able to use those documents. If you have trade secret stuff that you don't want to hand over, you need to seek a protective order again to protect the confidentiality of those documents. The fact that it's a trade secret doesn't protect it from disclosure to the AG. You still have to hand it over, but you can try to get protections in place so that it won't be filed publicly. So these are just some examples of cases that show the broad reach of the statute and the kinds of cases that the Attorney General takes. Tobacco companies, that was a huge one. Antitrust violations, that was another. There's an entire portion of the statute that's related to antitrust violations, so that's one you'll see frequently. I believe there was a speaker from Partners here earlier today. Partners had an antitrust consent order entered with the Attorney General. The Judge Sanders, in the business litigation session, in an extremely unusual move, refused to enter. So the Attorney General and Partners had reached an agreement on this antitrust investigation they were doing, that they were going to allow certain things to happen and not others. And Judge Sanders said, nope, doesn't pass my scrutiny, and sent them back to the drawing board on that. But you will see antitrust come up in this context a lot. Exxon was a really high-profile one that I just want to talk about briefly, because you'll see that one in the news a lot. So Attorney General Healy was suing Exxon, or issued a civil investigative demand to Exxon, basically trying to get at research Exxon had done into climate change. So this is the effects of CO2 on the atmosphere. And it's kind of analogous to the tobacco litigation, where it turned out when you look at the tobacco company's files that they have been doing their own internal research on the health effects for decades before the public knew about it. So the theory was that Exxon may have similar kind of information internally that the Attorney General wanted access to. Exxon fought this tooth and nail. Fought it in federal court in Texas, in state court in Massachusetts, and eventually they brought it up to the Supreme Court. They were denied cert, so the Supreme Court didn't take it up. But Texas was essentially, Exxon was saying, we are in Texas. We have franchise. Yes, Your Honor, you may see a big Exxon sign right over there, but we're not in Massachusetts. We have franchises in Massachusetts, but that's different. That's not us. And also, this is political. This is, you're trying to silence us in the climate change debate. This is an improper use of your power. Despite that fight, Exxon lost on every front, and it was required to hand over the documents that Moore Healey wanted, and that investigation is ongoing. So typically, just how do these end? What are the remedies available? There are fines, and they add up quickly. $5,000 per violation, $10,000 if you're violating a injunctive relief of some sort, restitution to the people that have been harmed, should you be found to have harmed someone. If it's a securities-related breach of 93A, it could be double or treble damages. And often what you'll see at the end of all of this is something called a consent decree or an assurance. So it's an agreement between the party being sued and the government that you'll stop the behavior, that you'll pay back some fees, there's penalties, and you pay the Commonwealth's attorney's fees as well. So kind of harder for us to get our heads around in private practice because we bill by the hour and all of that. But the Attorney General's office takes what would be a reasonable private fee for this attorney with those number of years of experience and is allowed to apply that fee. So you're paying back the state for their time as well. So there's so much more that I could say about this, but I'm mindful of the time. I just want to sort of flag the issue for you because sometimes, again, you'll have clients that, as with the private lawsuits, get a CID like this across their desk and just don't see the red sirens are not going off for them, and they should be. It's very serious, and it's something that has very tight deadlines and needs to be dealt with.
One other point I wanted to add in terms of the reasonableness standard, the burden is on the defendant in proving reasonableness. So when you get to the point of whose job it is to prove it and establish reasonableness, that burden is yours as the responding party. It's not going to be the plaintiff's job to establish reasonableness. So you have that burden. It's an important distinction for trial attorneys thinking about this, is just how reasonable is reasonable. Another thing, there's a case in which a defendant received a defense verdict on all claims, and the judge still awarded the plaintiff 93A damages. So it's not even that, something cannot be a breach, something cannot be technically a tort from the jury's perspective. And the judge takes a look at the conduct and nevertheless found that it was so egregious that it rose to that level. So be aware of the seriousness of it. Whether the reasonableness comes down to if you have to retain an expert, if it's a technical thing. You've got I think the balancing act as an attorney when you get one of these things is figuring out how much more information you need to ask for, because you do have a duty to inquire further to make sure that you're getting what you need to respond reasonably with not needing to do the other side's homework. And I can't tell you exactly how to deal with it, but I can tell you, look at the case law when that happens, balance those interests, and make an informed decision, advise your clients accordingly. So thank you.
Any questions?